Your audio, check your audio if you can hear me. Check your audio. Check your audio. Unmute.
If you're not talking,
I'm so sorry, my lord. In the National Industrial Court of Nigeria, holding at Abuja, Wednesday, 8 May of 2024, before His Lordship, Honorable Justice Oyewumi, case number NICN ABJ 160-2021 between Mr. Michael Richard and Dennis Hotel Limited and another. My lord, parties are absent.
Is there any party online?
No, my lord.
Appearances.
May it please my noble lord. My name is Speaker Henry Eze.
My lord, I can hardly hear you.
Check your audio. You may need to increase your audio because I'm speaking loud. Your Nene friend can hear me. Peter, what?
Speaker Henry Eze.
Very well.
My lord, appearing with me are my learned friends, Maxwell C. Umesie, Ebuka Ikora, My lord, together we appear for the claimant.
Very well. Any other appearance? Any other appearance? Mr. Ogulafo, please, all others, court clerk, court registrar, mute yourself, Mr. S.C. Arua and co, mute your phone. And let me hear from Mr. Ogulafo. Mr. Ogulafo, mute your phone. Unmute your phone, Mr. Ogulafo. Announce your appearance. Announce your appearance. Mr. Tony Ogulafo. Mr. Tony Ogulafo, can you hear me? Unmute your phone and announce your appearance. Well, I've recorded that Mr. Tony Ogulafo is for the defendant.
My lord, respectfully, may I draw the attention of my lord?
Yes.
My lord, we did the adoption for this case was done on the 7th day of February.
Yes.
My lord, going by my calculation, my lord, that today seems to be 91th day. We may be one day.
The 7th day will not be computed.
Very well, my lord.
The 7th, check the Interpretation Act.
Very well, my lord.
The 7th is excluded. So the date starts counting from the 8th.
As the court pleases.
Very well. Mr. Ogulafo, can you hear now? Please, Mr. Arua, mute your phone. Mute your phone. Mr. Ogulafo, something must be wrong with your audio, but I'm going on to read the judgment, please. Mr. Ogbulafor, can you hear me? Mr. Ogbulafor. Mr. Ogbulafor. Well, I'll proceed with the judgment of the court. I can see you online. Possibly you have issues with the audio. So I'll proceed with the delivery of the judgment. This action was commenced by a general form of complaint dated and filed on the 19th of July 2021, subsequently amended on the 22nd of February 2022, wherein claimant prayed the court for the following. 1, a declaration that the defendants have the duty of care and responsibility of training the claimant in the use and handling of corrosive chemical known as Magic 45, and also to provide him with reasonable protective gears, including eyeglass, safety suit, and boots before instructing him to use and handle the corrosive chemical. 2, a declaration that the failure of the defendant to train the claimant in the use and handling of corrosive chemical known as Magic 45, and also to provide him with reasonable protective gears, including eyeglass, safety suit, and boot, before instructing him to use and handle the said corrosive chemical, which resulted to the life-threatening injuries and claimant's loss of his left eye, amounts to negligence. 3, a declaration that the failure of the defendants to provide the initial cash deposit to Dr. Hassan Hospital, Maitama, Abuja, for immediate and prompt treatment of the claimant and delayed payment of the claimant hospital bills, on which basis he was denied access to the eye specialist or surgeon to remove the surgical stitches on his left eye, which resulted to claimant's complete loss of his left eye, amounts to unfair labor practice and negligence on the part of the defendants. 4, another compelling the defendants to pay the sum of 150 million naira only to the claimant as compensatory damages for the claimant's loss of his left eye and life-threatening injuries the claimant sustained in the course of his employment arising from the defendant's failure to train the claimant in the use and handling of a corrosive chemical substance, and prompt payment of hospital bills which occasioned the loss of the claimant's left eye. 5, an order for the sum of 50 million naira as general damages for the defendant's negligence to train the claimant in the use and handling of a corrosive chemical substance and prompt payment of hospital bills occasioning claimant's loss of his left eye. 6, an order for the sum of 150 million naira being the unpaid salary for the months of April, May, and June 2020 at monthly salary of 30,000 naira and 10% interest of the salary until judgment is delivered. 7, an order compelling the defendants to pay the sum of 30,000 naira to the claimant as arrears of salaries payable from the month of February 2021 until judgment is delivered. 8, an order compelling the defendants to pay the claimant a monthly interest of 10% on judgment sum upon default of payment after judgment is given until the judgment sum is liquidated. And 9, an order for the sum of 2 million naira as the cost of prosecuting this suit. In the alternative, the claimant is claiming 1, declaration that the defendants have a duty of care and responsibility of training the claimant in the use and handling of corrosive chemical known as Magic 45, and also to provide him with reasonable protective gears, including eyeglass, safety suit, and boot before instructing him to use the corrosive chemical. 2, declaration that the failure of the defendant to train the claimant in the use and handling of corrosive chemical, and also to provide him with reasonable protective gears, including eyeglass, safety suit, and boot before instructing him to use and handle the said corrosive chemical, which resulted to the life-threatening injuries and claimant's loss of his left eye, amounts to negligence. 3, declaration that the failure of the defendants to provide the initial cash deposit to Dr. Hassan Hospital, Maitama, Abuja, for immediate and prompt treatment of claimants and delayed payments of the claimant's hospital bills, on which basis he was denied access to the eye specialist or surgeon to remove the surgical stitches on his left eye, that resulted to claimant's complete loss of his left eye, amounts to unfair labor practice and negligence on the part of the defendants. 4, an order compelling the defendants to pay the claimant a periodic payment equal to 90% of claimant's loss of remuneration of 30,000 naira only resulting from loss of his left eye until he reaches 55 years of age. 5, an order for the sum of 50 million only as general damages against the defendants for their neglect or failure to train the claimant in the use and handling of the corrosive chemical and substance and prompt payment of hospital bills, which occasioned the loss of claimant's left eye. 6, another for the sum of 150,000 naira, being the unpaid salary for the months of April, May, and June 2020, at monthly salary of 30,000 naira, and 10% interest of the salary until judgment is delivered. 7, another compelling the defendants to pay the sum of 30,000 naira to the claimant as arrears of salary payable from the month of February 2021 until judgment is delivered. 8, another compelling the defendants to pay the claimant a prompt interest of 10% on judgment sum upon default of payment after judgment is given until the judgment sum is liquidated. And finally, another for the sum of 2 million naira as the cause of prosecuting the suit. The case of a claimant is that he was employed as a steward in the food and beverage department, but he was not trained on handling any corrosive chemicals, and that his job description as steward is serving dishes at the restaurant of the first defendant, washing dishes and assisting in the kitchen at food and beverage department of the first defendant. However, that while on duty on the 10th of May 2019, he suffered serious injury from a chemical substance used for cleaning, which led to loss of his left eye, severe burns on all parts of his body due to the failure of the defendants to provide him safety gadgets and proper training. Furthermore, it is the avowment of the claimant that during the accident he was not supervised, neither was he aware of how dangerous the chemical is to his life, because he has never handled same until the day of the accident. He stated that the defendant told him duty of care to provide him prompt medical care, payment of his hospital bill, and to train him in the use of a corrosive medical substance, and which duty it failed to do. The injury he sustained and the attitude of the defendants to his medical treatment led to the permanent loss of one of his eyes. He also averred that the first defendant failed to pay his monthly salary for the month of April, May, and June 2020, but that the defendants started paying him again from August 2020 and stopped in February 2021. Thereafter, his lawyer wrote a letter to the defendants demanding for compensation, which later revealed that the defendants, despite being aware of claimant's accident, failed to apply for his compensation. It is in view of this that he has approached the court for justice. The defendant, in response, filed their consequential amended statement of defense, dated and filed on 5th of April 2023, maintained that claimant was trained in the handling of a corrosive substance, that all necessary protective wears and safety kits were provided for the claimant to discharge his duty. But he chose not to make use of it, as seen by other staff in a playful mode without concentration and due diligence, which resulted in his injury. The defendants further averred that they have discharged their duty of care to the claimant by providing all the needed personal protective equipment, and the defendant did pay for claimant's medical treatment. Claimant's salary was paid like other staff to COVID-19 lockdown, and that the defendant resumed payment after the restriction was lifted to February 2021 when claimant resigned. In furtherance to the above, the defendant proceeded that they have been doing their best in trying to assuage the plight of the claimant and has applied to NSITF to pay compensation to the claimant with all statutory fees paid, making the claimant eligible for compensation, reiterating that they were not negligent in their dealings with claimant and have been compensating him since the incident and even offered him continued employment, which he refused. Thus, he cannot be claiming for loss of earnings when he is the one that walked away from his job in pursuit of shadows. They urged the court to dismiss this suit. During the course of trial, one Augustine Eziadu testified as CW1. He adopted his sworn deposition. He equally tendered documents admitted as Exhibit A, was also examined by the defendants. One Inyo Ephraim Tezungwe equally testified for the claimant as CW2. He was a subpoena witness, tendered bundles of documents admitted and marked as Exhibit Inyo. Claimant himself testified for himself as CW3. He adopted his sworn deposition. He tendered documents admitted and marked as Exhibit M to M9. He was equally examined by the defendants. The defendants called one Patricia Chukwu, who testified as DW1. She adopted her written deposition as her witness statement in this case and was cross-examined by the claimant. The defendants also called one Evelyn Home, who testified as DW2, Charles Indenu testified as DW3. They all adopted their sworn deposition on record and were cross-examined. Indenu tendered documents admitted and marked as Exhibit C to C5, was thereafter, like I said, cross-examined by claimant counsel. The defendants also subpoenaed one Perry Diata, who testified as DW4. He adopted the deposition the court had asked earlier that he should reduce into writing and tender document, which was admitted as with C6 and was equally cross-examined by the claimant counsel. At the close of trial, both parties filed their respective final addresses. I have reduced them into the body of this judgment, so I'll go straight to the decision of the court. I've carefully read all the processes filed by both parties, considered testimonies of all the witnesses and documents tendered, final written statements of both learned counsel. It is from all these I humbly distill these issues for the determination of the court does. One, whether the injury sustained by the claimant is as a result of the negligence of the defendants, and two, whether the claimant on the preponderance of evidence has proven his case to be entitled to the relief sought. I would like to address the contention of the learned counsel to the defendants during trial on the 17th of January 2022 to the admissibility of Exhibit MA, a bank statement of account on the ground. The same is a computer-generated evidence and with no oral evidence certifying its content or certificate of compliance. The Court of Appeal, in the case of UBN PLC versus Agbo 10 and another citation provided, accepted the argument that the position of the law in the case of Kubo and Dixon is applicable because statement of account is a computer-generated evidence. However, in the recent decision of the same Court of Appeal, in the case of Shehu and FRN and others, the court held otherwise. Therein, the court held that a computerized statement of account does fall within the category of documents absolutely inadmissible in law, as it is admissible under Section 91 of the Evidence Act in relation to the documents under Section 89(1) of the Evidence Act, and that it is not a computer-generated evidence and thus need not be certified. However, the Apex Court in the case of Attorney General of the Federation and Anuebunwa, citation provided, Oyewumi GSC at page 270, paragraphs F and G to H, has held otherwise. The court in the above case held that a statement of account is a computer-generated evidence in line with Section 84 of the Evidence Act because it is algorithm stored in the database of the bank that produces the statement. The Apex Court in the above case also emphatically held that the mere fact that a document is typed using a computer does not make it a computer-generated evidence. But what makes it a document computer-generated is information stored on the computer because according to the court, Section 84 of the Evidence Act intends that only complex evidence generated from the computer against which the calculating or measuring accuracy of the computer is depended upon or stands to be tested is to be subjected to scrutiny by the courts and not ordinary documents printed out of a computer. By the doctrine of stare decisis, the position of the Supreme Court puts the matter to rest, and this court is bound by saying, see the case of Oyewumi and CBN, Dalatu and Turaki and others. Besides, in my humble view, there's no disputing the fact that the statement of account sought to be tendered had its origin from a computer, whether or not it is asserted to be extracted from an electronic ledger, which to all intents and purposes the information therein was imputed through a computer, and the printout also derived therefrom. It is thus a computer-generated evidence. The said Exhibit M4 was not certified as required by the Evidence Act. Same is hereby not admissible. The position of the law is clear that the court is duty-bound to treat an inadmissible evidence which it admitted inadvertently as if it was never admitted, and thus expunge the same from the records at the stage of judgment. See Capital Hotels PLC and others versus Abdullahi, the case of UBN PLC and Ajabule and another. Exhibit M4 is hereby expunged from the record of this court at this stage. Then the defense counsel also on the 19th of January 2022 told the court he is objecting to Exhibit Inyo and told the court that he reserved his right to object to the admissibility of the said document in his final written address. However, he failed to address the court on the admissibility of the said document in his final written address as undertaken. The position of the law is that generally an objection to admissibility of a document should be made at the time the document is being tendered. In other words, the proper time to object to admissibility of document is when it is being tendered. See Ogumbo Dede and FRN, case of Sunday and the state, Dawu and the state, Guntayo and Adelaja and others. However, nothing precludes a party from raising an objection to a document if the document is by law in itself inadmissible in all circumstances, and such document cannot be acted upon by the court, even if admitted without objection. In essence, when the admissibility of a document is subject to certain conditions, the party objecting thereto must raise the objection timeously, otherwise is a stop from raising same later. See Kazim and the state, Husseini and the state, or Shaw and Akpe. Since the learned defense counsel failed to address the court as to the admissibility of the document in its address, as he had undertaken to the court, it is presumed that he has no objection to the document. Besides, it must be noted that the said exhibit in your contains the payslip, offer of appointment, confirmation of appointment, and response to letter of resignation of CW2, a supreme witness, and find them to be an original of the said documents. And the defendants have not told the court anything precluding them from being admitted. The position of the law is settled that when the defendant has not taken any objection to the admissibility of a document tendered by claimant, the same is taken as admitted. See Shurumo and the state, NBC and Ubani, the case of NBC and Ubani. As such, Exhibit Inyo is taken as admitted and thus still forms part of the record, being a document that is relevant and admissible in law. Also, on the 28th of June 2023, during trial, learned defense counsel objected to the admissibility of Exhibit M8, particularly the Federal Polytechnic Nassarawa application details form, on the ground that same is a photocopy of public document that ought to be certified. Public document by Section 102 of the Evidence Act as amended has been classified into two. See the case of Agbola versus ASB Investment Limited. A peruse has been made, and it is Section 91C of the Evidence Act as amended that has made it abundantly clear that the only secondary evidence admissible of a public document is a certified true copy thereof and none other. See the case of Diamond Security and another versus Ogrinya, Dangai versus Abdulkadir and another. The said exhibit M8 is truly a public document of which the only secondary copy admissible is a certified true copy. It is thus inadmissible in this case and ought to be expunged, and it is hereby expunged from the court's record. Then I claimant's counsel on the 26th of October 2023 also objected to the admissibility of exhibit C to C5 when they were to be tendered on the ground that they were not pleaded and front-loaded and several other grounds which he raised in his oral submission before the court and his final written address, which grounds I'll proceed to address here. Then counsel submitted that the receipt from the hospital that is exhibit C was not front-loaded, and what was front-loaded was different from what was tendered. He also objected to the admissibility of a letter dated 17th of November 2021 for being document made during the pendency of this action contemplated under Section 83 of the Evidence Act as amended. First, let me say that the bedrock of admissibility is relevance and is governed by the Evidence Act and the pleadings of parties. See the case of Honorable Commissioner, Ministry of Lands and Survey, Makurdi and another, versus Abu and another, case of Main Street Bank Registrars Limited and Lukandu, citation provided. Once the document is relevant, it is admissible in evidence. The question of probative value is a different issue entirely. See the decision of the Apex Court in the case of Aundoka versus Obot and another, case of Abubakar and Chicks, citation provided. Also, it must be pointed out that the essence of front-loading is to speed up trial in the sense that front-loading of processes saves a lot of valuable time in litigations, as all facts or documents sought to be relied upon by a party are laid bare before the court. Also, a document cannot be rejected because it was not front-loaded, as front-loading has no bearing with admissibility. See the cases of Onuaha and Onuaha, Okboru and other versus Onuaha and others. Thus, it is not fatal, even if the said documents were not front-loaded or that the ones front-loaded are different from the copy standard. Also, Learned Claimant Counsel v. paragraph 3.0 to 3.12 objected to the admissibility of Exhibit C, C2, C3, C4, C5, and C6. The ground of his objection to Exhibit C, C2, and C3 were that they were not pleaded. I perused the amended statement of defense of the defendants, which is the extant process before this court. And I find that, as rightly submitted by Learned Counsel, Defense Counsel, the letter of appreciation herein as Exhibit C5 was pleaded at paragraph 24. Also by paragraph 26 of the amended statement of defense, the defendants averred that they paid all the medical bills from the hospital in respect of claimants in installments. That, to me, is sufficient facts to render the receipts pleaded. This is because it is not the law that a document must be specifically pleaded. It suffices if facts contained in the documents are pleaded or have nexus to the documents. Since the defendants averred paying all medical bills of claimants in the hospital in installments, they are therefore deemed to have pleaded the receipts which shows installmental payments of the hospital bills in respect of the claimant. So it cannot be said that Exhibit C and C5 were not pleaded as submitted by Learned Claimant Counsel. In view of the fact that Exhibit C and C5 were pleaded and there is nothing stated by the claimants rendering them inadmissible apart from the alleged failure to plea and front, load, both are thus admissible. I'll consider the admissibility of Exhibit C5 in the subsequent paragraph. Now, as regards the letter dated 17 November 2021, which is part of Exhibit C2, which consists of two documents dated 29th September 2021, written by the Defense Counsel, and the response to it by the Claimant Counsel dated 17th November 2021. That was objected to by Learned Claimant Counsel during trial. Section 83, subsection 3 of the Evidence Act as amended, under which Learned Claimant Counsel is raising his objection, admits two twin conditions that must coexist, to which the statement in the document must be made by a person interested, and two, it was made during the pendency or anticipation of a proceeding. The court have held that the target of subsection 83.3 is not generally documents made while litigation is anticipated or pending, but only statements in documents made by any person interested in such litigation in which such statements might tend to establish the facts in dispute in the litigation. See the case of Dung and UBA Limited, citation captured. It needs to be pointed out that when interpreting a law, the responsibility of anyone interpreting it is to find out the intention of the lawmaker, which can only be discovered from the words used. See PDP and Saror and others. Truly, SBC2 was made by an interested party, the defendant, during the pendency of this action, and this action was filed on the 19th of July 2021, and it was responded to by the Claimant Counsel. However, I do not think it will be excluded by Section 83.3 of the Evidence Act. I'll proceed to say why. The said letters were written by claimant's lawyer himself in response to the defendant's lawyer's own dated 29th of September 2021, requesting that the claimant send an attestation stating the date he received his last salary from the defendant to enable the NSITF calculate his compensation. Claimant's counsel replied and informed the defense counsel that since the matter is in court, they are both sub judice. It is claimant's lawyer himself that is now asking the court to reject the two letters. In the case of UBA PLC and Vertex Agro Limited, the Court of Appeal, per agim JCA, now GSC, held that equity can operate to prevent the use of Section 83.3 of the Evidence Act as amended to cause injustice. The claimant's counsel, who himself wrote in reply to the defense counsel's letter, which constitutes the same bundle of documents that is SBC C2, knowing that litigation was pending at the time he did, cannot be asking the court to exclude the same letters. Equity will operate here to render the said letters admissible. Accordingly, Exhibit C2 still forms part of the record of this court. The ground of objection to Exhibit C4 and C5, according to learned counsel, in his final written address, is that they are secondary evidence with no proper foundation laid for the whereabouts of their original. I perused both exhibits, and they are clearly photocopies for which no proper foundation were laid. It is compulsory to lay proper foundation before a secondary evidence of the nature of a document which is not a certified true copy to be tendered. See Abidoye and another, and Dusumu and another, PML, Secretary Company Limited, and FRN, Akao and the Nigerian Army. The essence of laying proper foundation for admissibility of secondary evidence is to assure the court that indeed the original exists. See Osahe and Amadasun. The defendants, having failed to lay proper foundation for exhibits C4 and C5, both are hearing held to be inadmissible and thus expunged at this stage from the record of this court. The ground of objection to exhibit C6, according to learned counsel in his final written address, is that it is a photocopy of secondary evidence and was not signed and or tendered through the maker. It is not the law that all documents must be signed. Exhibit C6 is a document showing details of payment from Dr. Hassan Hospital, where the defendants took the claimant to for medical treatment. I'm mindful of what DW4 in his examination in chief said as to the whereabouts of the original of the document on the 2nd of November 2023. According to him, the original of Exhibit C6 is with the NSITF. This fact was equally noted by claimant counsel in paragraph 3.10 of his final written address. DW4 has laid proper foundation for the whereabouts of the original of the said Exhibit C6. Also, the law is settled that pursuant to Section 37 of the Evidence Act as amended, evidence must be direct. It, however, amounts to hearsay if it emanates from someone other than the maker, and the purpose of adducing it goes beyond the fact that it was made to the point of asserting the veracity thereof. This then leads to the issue of documentary hearsay. Documentary hearsay arises, however, where the veracity of the content of a document sought to be asserted through a witness other than the maker thereof, and who is thereby unable to testify or be examined on the veracity of its content. See Monday and FRN, the case of Tasiu ATS versus Samani. Although a document may be tendered through a person other than the maker, the purport of which is that he cannot be cross-examined on it. The document cannot therefore attract the intended value. In fact, it cannot have any weight. It is tried that a witness who tenders a document or presents evidence must be available for cross-examination before it can be evaluated for weight. CFRSC and others versus Incorporated Trustees of Risk and Accident Prevention Society of Nigeria, Udom Gabriel Emmanuel, Umana, Okon Umana, and others. Thus, not tendering Exhibit C6 through its maker does not affect its admissibility, but the probative value to attach to same. In view of the above, I therefore do not see anything standing in the way of the admissibility of Exhibit C6 to render it inadmissible. It does forms part of the record. I need to say a word or two as regards Exhibit M9, which is that the audio recording contains in the flash drive. There's no doubt that Exhibit M9 is a computer-generated evidence under Section 84 of the Evidence Act. The Supreme Court, in the case of Dixon and Silva, Penway is a JSC held that a computer-generated evidence in the nature of video recording in a DVD, apart from fulfilling the conditions for admissibility under Section 84 of the Evidence Act, must also of necessity be linked to the case of parties in the sense that parties must demonstrate its content in the open court. The court was of the view that in order to discharge the requirement which will facilitate the court's attachment of weight to them, it must be demonstrated in the open court by its contents being played therein, as this would not only allow the party tendering same to link it to its case, it will equally afford the opponents the opportunity of testing and contesting the accuracy in the usual adversarial method of cross-examination. See also the cases of Chukwe Kere and INEC and others, the case of Kubo and another and Dixon and others. It is thus clear from the above authority that a DVD being a computer-generated evidence to be admissible I'll take that again. It is thus clear from the above authority that a DVD, being a computer-generated evidence to be admissible, must satisfy the condition of admissibility as contained in Section 84(1) and 2 of the Evidence Act as amended. A flash drive containing a video, that is Exhibit M9, is in the nature of computer-generated evidence as stated supra. Thus, the flash drive must be certified either by oral evidence or by a certificate in line with Section 84 of the Evidence Act. After it scales the hurdle of admissibility, it must at some point be examined by demonstration in the open court, which is usually by playing same at some point, else it will remain a dormant or sleeping document because the court has no duty playing the said DVD outside the courtroom, as this will amount to scouting for evidence for a party. In the instant case, Exhibit M9 was only accompanied by a certificate of compliance. It was not demonstrated in the open court, so claimant could not be cross-examined on its content as required by law. Claimant only told the court he would want the court to listen to its content in its continuation of evidence on the 1st of February 2023, but no application to that effect was made by the learned counsel on its behalf. Our adversarial jurisprudence prohibits a judge from embarking on an inquisitorial examination of documents outside the courtroom, as the court is an adjudicator, not an inquisitor. A fortiori, it is anathema for a judge to act on what he discovered from such a document in relation to an issue when that was not supported by evidence or was not brought to the notice of the parties to be agitated in the adversarial procedure. Although claimant on the 1st of February 2023 will want the court to listen to say, the hands of the court are tied, having not been demonstrated in open court. The content of Exhibit M9 was not demonstrated in open court by playing to give the defendants opportunity to cross-examine claimants on its content. Exhibit M9, even though certified by a certificate of compliance, having not been demonstrated in open court, is a dormant or sleeping that has no probative value, even if the court decides not to expunge it. I so find and hold. Defendant B, their final written address, submitted that the second defendant ought to be discharged from this suit as he is not liable to the claimant, as is not his employer, and that is only an agent of a disclosed principal. The first the disclosed principal, the first defendant. In considering whether a person is supposed to be a party in a particular suit or matter, the following two issues are to be considered by the court. A, is it possible for the court to adjudicate upon the cause of action set up by the plaintiff unless the person is added as a defendant? B, is the person someone who ought to have been joined as a defendant in the first instance? Or C, alternatively, is the person someone whose presence before the court as defendant will be necessary in order to enable the court to effectually and completely adjudicate upon and settle all the questions involved in the cause? C, Issa and others versus AA Rano Construction Limited. In case of Olawumi, Oluwani, and Adewumi, the court, in order to determine the above, will consider the pleadings of parties in the case. See the case of Chief of Army Staff and Lawal. I'll peruse the 35 paragraphs of the claimant's statement of fact, and I can tell and find, I find by the averment of the claimant in paragraphs 24 to 26 of the said statement of facts that the second defendant was made, that the claimant was made by the management of the first defendant to write a letter of appreciation to the second defendant for paying his hospital bill as a condition for the continuous payment of his salary, excuse me, which was done. Though this does not allege any specific allegation of wrongdoing against the second defendant in relation to claimant's action, which is for negligence. However, the fact that the second defendant is the alter ego, the mind, soul, and body of the first defendant, and in the circumstance of this case, wherein he had to be mandated, according to him, by the management of the first defendant to write a letter of appreciation to the second defendant, speaks volumes of the power the second defendant wields in the first defendant. It is correct that an incorporated company is an entity different and distinct entity from its managing director or human agents who act for it. The AfriBank Nigeria Limited versus M Enterprise, Okata and Registered Trustees, OSC. The consequence of recognizing the separate legal personality of a company is to draw a veil of incorporation. Excuse me, please. The consequence of recognizing the separate legal personality of a company is to draw a veil of incorporation over it. Excuse me, please, just a minute. Let me clear my. Mr. Ogbulafo, please mute your phone.
I can hear you, my lord.
I said mute your phone. Mute your phone. The consequence of recognizing the separate legal personality of a company is to draw a veil of incorporation over it. See Section 37 of the Companies and Allied Matters Act 2004, hereinafter referred to as CAMA, which was the applicable law when this cause of action arose. However, since the statute will not be allowed to be used as an excuse to justify illegality or fraud, the court will leave the veil of incorporation where a company is being used to perpetrate any illegality, or in a circumstance as in this case, where the company cannot act without the alter ego, who has to release funds for payment of his hospital bills and other bills. The doctrine of alter ego in law allows the court to disregard the separate corporate existence of a company to hold an individual responsible. The Supreme Court in the case of Oyewumi and the state explained the word alter ego, and that it's a doctrine. I mean, the court held that alter ego is said to mean quote unquote second self, and that under the doctrine, the court merely disregards corporate entity and holds individual responsible for acts knowingly and intentionally done in the name of a corporation. In law, a director of a company is an agent of a company. See Oriebosi and Andy Sam Investment Company Limited, and the case of Esang and Oriel Plastic Limited. However, it must be noted that just like every legal principle, this general rule permits some exceptions. Thus, the defense counsel was clearly incorrect when he tried to generalize the aforementioned position of the law on the liability of an agent of a disclosed principal. The fact that a person is an agent and is known to be so does not of itself necessarily prevent his incurring personal liability. The law strikes that an agent of a disclosed principal may also be liable just as the principal. Having due regard to the facts of the case, the circumstance of the event leading to the cause of action in this case, the claimant alleged that the delay in releasing funds for his treatment at the time affected his eye, most especially in a company that is mostly owned by one man or a few persons, as in this case. See the case of Issa and others as AA Random Construction Limited Supra, the case of Ashafa Foods Factory and Alrain Nigeria Limited Supra. It is in view of this that I find that the second defendant, being the alter ego of the defendant, is an important party in this case, without whom this case cannot be effectually and finally concluded, and thus refuse to strike out his name from this suit. I so hold. Now to the crux of the case at hand. Claimant in this case alleges a breach of duty of care on the part of the defendants, which has now led to the permanent injury sustained. In order to succeed in an action for negligence, a claimant must prove the trilogy of A, duty of care, B, breach of duty of that care, and C, damage resulting from the breach of the duty of care owed. Also, negligence is a question of fact which is proved by oral and/or documentary evidence. See the case of Access Bank versus Mann, the case of FBN, PLC, and Ode, the case of UTB and Ozemena. Thus, the fact of what amounts to negligence was pleaded and proved by the party alleging same. It is not in dispute that claimant was an employee of the defendant and that he sustained an injury in the course of his employment, which led to the loss of one of his eyes. Before proceeding, let me address the contention of the defendants in its final written address that claimant did not give particulars of negligence, just a minute, of negligence alleged, and which is fatal to his case. There's no doubt that in an action for negligence, a party claiming must specifically please him by giving particulars. The question then is, can one say claimant has not given particulars of negligence in this case? In resolving this, I will rely on the decision of this court per Kanyib J. Now, the Honorable the President of this court in the case of Babatuli Ajala and Right Power Company Limited is an unreported suit of this court, NICN/LA 432/2013, judgment delivered on 28th of January 2019 at paragraph 37 and 38 thereof, wherein he held thus, I quote, there's another aspect of the defendant's objection, that the claimant did not give any specific particular of the negligence either in his pleadings or in his evidence or even prove same. The requirement that a claimant must give particulars of negligence in an action for negligence is one that case law authorities acknowledge. See, for instance, Diamond Bank and Partnership Investment Company Limited and another, which held that a plaintiff as a matter of law is required in an action on negligence to state or give particulars of negligence alleged and to recover on the negligence pleaded in those particulars. It is not sufficient for a plaintiff to make a blanket allegation of negligence against the defendant on claim for negligence without giving full particulars of the items of negligence relied on, as well as duty of care owed to him by the defendant. And by PW Nigeria Limited and Mansell Motors Limited and another, to succeed in an action for negligence, the law is settled. As to the standard of pleading and proof required, as a matter of law, therefore, a plaintiff who intends to be victorious in negligence action must plead the particulars of negligence alleged and give cogent and credible evidence at the trial in line with the detailed pleadings. It is not sufficient pleading for a plaintiff to make blanket allegation of negligence against the defendant without giving detailed particulars of the item of negligence relied on, as well as the duty of care the defendant owes him. Certainly, the law does not permit the trial judge to fill in the gaps for the plaintiff where the pleading lacks necessary particulars. This position of the law is inevitable because what amounts to negligence is not law, but a question of fact which must be decided according to the facts and circumstances of a particular case. The question, however, is, when the law requires the particulars of negligence to be given, is this requirement met only when there is a separate part of the pleadings headed quote and unquote particulars of negligence? I do not think so. So long as what makes up the negligence given in the pleadings, just so that the defendant knows what he must defend, the requirement of particulars complained of would have been met, unquote. See also the decision of this court in the case of Mohammed Basiru and NJZC International Construction Nigeria Limited on reported suit of this court NICN/LKJ/31/2022, a judgment I delivered on the 4th of March 2024, in the case of Aniofik Akpan Udo and Alibat Production Nigeria Limited on reported suit number NICN/ABJ/08/2023, judgment I delivered on 29th of February 2024. Also in the case of AG Leventis Nigeria PLC versus Akpu Supra, which both parties relied on in their final written addresses, the Supreme Court held that a plaintiff or claimant in this case may not specifically set out the particulars of negligence in his pleadings. That omission could be cured if the relevant details are contained in the other paragraph of his pleadings. It is deducible from the above authority that once the facts pleaded are properly suited under the tort of negligence and are sufficient, that will suffice. In the instant case, claimant read paragraph 6 to 17 in his amended statement of facts gave sufficient particulars of negligence. In my view, statement of facts reveals two things, which conveniently serve the purpose of particulars of negligence. The claimant complains of. The four things are: one, that the defendant owed him a duty of care, which was breached. Secondly, that he was not trained in the use of corrosive chemical Magic 45. Thirdly, that the defendant failed to provide him with protective gears, including eyeglass, overall wear boot, knowing the hazardous nature of the chemical, and finally, the failure of the defendant to give the doctor the details of a corrosive chemical in order to determine line of medication. These are particulars of negligence that the defendant must answer to in this suit. It is immaterial that he did not include a separate part in his pleadings titled, quote unquote, particulars of negligence. To hold that claimant has only pleaded negligence only when he specifically carved out a particular part of his pleadings and titled it particulars of negligence is to sacrifice substantial justice on the altar of technicality. See the case of University of Ilorin Teaching Hospital and Abegunde Supra, which was relied on by claimant in his final written address. I accordingly find and hold that claimant gave sufficient particulars of negligence in his pleadings. The question remaining is whether he proved these particulars of negligence as to be entitled to damages against the defendant. As such, the submission of learned defense counsel in his final written address is misconceived and thus discountenanced. Now back to the trilogy that needs to be proved for an action in negligence to succeed. It needs to be pointed out that employment relationship may give rise to both contractual and tortious liability. See the case of Afrap Chemical Limited and Owodwenyi Supra, particularly at pages 26 to 27, paragraphs F, and the case of Cabo Air versus Muhammad. A duty of care is said to arise when two persons are so closely and directly related that the activities of one of them may involve an appreciable risk of injury to the other. Such a close and direct relationship exists between an employer and his employee. And thus, under the ordinary principle of tort, the employers owes a duty of care to their employees. The duty of care owed by an employer to an employee is statutory under the Factories Act where applicable. See the case of Green Park Rubber Industries Limited and Osai. Also, where an employee sustains injury to the breach of the above duty, he can proceed under the statute, and which in Nigeria is Employees Compensation Act 2010. The duty is also owed under common law. See the case of Adeton and Edet. Court of Appeal in the case of Bello versus Dada and another, per Sankey JSCA, now GSC, held that generally in law, where there exists a service relationship between employer and employee, the former is under a duty to take reasonable care for the actions and safety of the latter in all the circumstances of the case, so as not to cause harm to others or to expose him or employee to unnecessary risk. See also the case of Yeri and Bender Feed and another and Floor Mills Limited, citation provided. It is therefore not in doubt that the defendant in this case owed claimant a duty of care. I so find and hold. The next hurdle is to determine whether the defendant breached the duty of care owed the claimant. I must say here that the duty of care owed to claimant by the defendants is to provide a safe workplace and environment. It also includes safe equipment and protective equipment by way of personal protective equipment, also known as PPE. This duty extends to ensuring that the PPE provided are worn by the employee. Claimant in the instant case alleged that he was not trained in the use of a corrosive substance, which led to the injury sustained at his workplace. The defendant refuted this and contended otherwise. Claimant in paragraph 6 of his written statement on oath stated that he was only trained in serving dishes, washing plates, and assisting in the kitchen. He also stated while under cross-examination by learned defense counsel on the 1st of February 2024 that the defendant does not train staff for what they do and that he was only trained to serve buffet. He must say, I must say that it is enough to show that claimant was trained as a steward. The defendant must go ahead to show that claimant was actually trained in the handling of a corrosive chemical. The claimant contended in the negative sense that he was not trained in the use of a chemical, while the defendants contended in a positive sense, that is affirmative, that claimant was trained. In my humble view, the defendants have the onus to prove that claimant was trained in the use of a chemical known as Magic 45. I say so in view of the settled position of the law that the burden of proof rests with the party who asserts the positive and not on one who affirms the negative. The maxim is he who asserts must prove. See sections 33 to 134 of the Evidence Act as amended. In the case of Amale and others versus Mustafa, Obidima and Otuonye, Anya and Anya. It is worthy of note that DW, while under cross-examination, went asked if he has any evidence to show that claimant was trained in the use of a particular chemical magic 45 that caused his injury, stated that he does not have any document in court. One would wonder what DW was doing in court as a witness in an action for negligence without proof to show that the claimant was trained on how to use a particular magic 45. I do not lose sight of the submission of Learned Defense Counsel Gulafor Esquire in paragraph 3.8 of his final written address that DW2 has stated that she and claimant were trained. On 26 of October 2023, DW2 stated in her oral evidence that on the third day, she was on duty with claimant, and she stated that claimant was a steward whose duty it is to clean drainage and wash dishes. She also stated that she was trained in her job and claimant was also trained. In my view, that piece of evidence is not sufficient to show that claimant was indeed trained in the use of the said magic 45 corrosive substance. By the nature of the chemical being a corrosive one, the defendant has to place some documentary evidence before this court that claimant had the necessary certification to use a corrosive, dangerous substance of that magnitude, and not just by mere ipsi dixit of a witness who is also a staff of the defendants. Now, let me deal with the contention of the defendants that claimant has used the chemical magic 45 over time and knew that same is corrosive, having had knowledge that it injured one Celestine. The law is on a firm stance that where injury occurs from the breach of a duty or in any other situation where the law allows a term to be implied into the contract, it is not enough for the employer to merely prove that the employee accepted the work or continued to do the work with full knowledge of the risk involved. He must go further to prove that the employee undertook with full appreciation that the risk will be on him. The mere knowledge of a danger is not sufficient. See Smith and Baker, where the House of Lords came up with a definite position that an employee engaged to hold a drill, in the process of which one of the stones slipped from the crane and injured the plaintiff, causing injury, was entitled to compensation, and that voluntary non-fit injury did not apply. In my view, the mere fact that the claimant knew it was corrosive does not mean that he consented to incur the risk which he may encounter in the course of the work. He might have continued in the work only because he does not want to lose his only means of livelihood. See the Nigerian case of Afra Care Limited and Owodoyin. Thus, it is immaterial that he knew the substance was corrosive, having used it over time, and knew it injured a co-employee. In any case, the fact still remains that there is no evidence on record to evince that claimant was trained on the use of a chemical magic 45. By the decision in the Nigerian case of IIT and Amrani, a master's duty towards his servant is to see that reasonable care is taken of the employee, and his duty extends to provision of safe equipment, safe fellow employees, safe place and system of work. Claimant in this case alleged that he was not given any PPE for work, especially safety goggles, and overall, the defendant contended otherwise, that claimant was provided the necessary protective kit and safety wears in the discharge of his duties, but he chose not to make use of it. DW1 also reiterated in her written statement on oath that the defendant provided the department with necessary personal protective equipment they need to discharge their duties. It is interesting to note that on the 1st of February 2023, throughout the cross-examination of claimant as CW3, defense counsel never cross-examined him on his testimony that he was not given a PPE. The position of the law is settled by the Apex Court in the case of Gaji and Baye, that the effect of failure to cross-examine a witness upon a particular matter is a tacit acceptance of the truth of the evidence of the witness. See also Gambo and Issa and another, Zenith Bank versus Nacoil International Limited. Learned Defense Counsel in his final written address kept arguing on how claimant was given personal protective equipment, that is the PPE, but he failed to cross-examine claimant on this material point, knowing fully well that the defendant, being the one asserting the positive that claimant was given PPE, is the one with the onus to prove. This failure is fatal to the case of the defendants. In any case, by the case of Ajao and Western Nigeria Trading Company Limited citation captured, an employer's duty at common law is not only to provide an employee with goggles or other safety equipment, but also to see and ensure that the employee wears them. See also the decision of this court in the following cases: Ola Suleiman and Hongzin Steel Company Limited on reported suit number NICS/LA/73/2011, judgment delivered on 26 February 2015, case of Bright Chinedu, Wardi, and Differential Aluminium and Steel Company Limited and another. Is also an unreported suit number NICS/CA/75/2012, a judgment delivered on 21st January 2014. Thus, even if claimant was provided PPE in this case, which has not been proven, the defendant still has a duty to ensure he wears them when needed. I must not forget to also say that the duty of an employer to an employee extends to the duty to supervise his employee and ensure that the employee observes the safety rules of the company. In the case of Ajao and Western Nigeria Trading Company Limited Supra, the court held that pursuant to an employer's duty of safety, an employer is under an obligation not only to provide safety devices, but also to give strict instructions followed by supervision in order to ensure that the employee adheres in the course of employment. The court in that case held that the duty of the employer at common law is not only to provide safety goggles, but also to ensure that they are used by the employee. In like manner, in the instant case, it is not enough for the defendant to show that claimant breached safety rules. It has to show that it gave strict instructions and supervision to claimant to ensure he complied with safety measures, and that despite this, claimant still breached the safety rules. Claimant, by his pleadings and statements on oath, maintained that on the day of the incident, that is the 10th of May 2019, one Mr. Silas, who was his supervisor in his department, instructed him to mix the said Magic 45 chemical. Noteworthy is the testimony of DW1. I will take that again. Noteworthy is the testimony of DW1 under cross-examination that the said Mr. Silas, who was claimant's supervisor, was not on duty when the accident occurred, that he appointed claimant as the chief leader because claimant was diligent in his work. If claimant worked on that day without supervision, while using a chemical corrosive substance, the defendant, in my view, cannot absolve itself of liability, especially in this instance, where the defendant has failed to prove that claimant possessed sufficient training as to the handling of the said corrosive substance. Also, I bear in mind the sworn deposition of DW3 at pages 373 to 379 of the record, and DW4 in their written statement on oath at pages 430 to 432 of the record of court that claimant was trained and given protective equipment. DW3, one Charles Indeno, is a general manager in the defendant. DW4, one Pierre Deati, was also a general manager in the defendant. I also bear in mind the testimony of DW2, who stated that claimant was trained, with testimony I have treated earlier. It is important to state that DW2 said that his work was in the kitchen, but claimant's job was a steward who cleans dishes and drainage. None of the witnesses was claimant's supervisor. The case and evidence of both parties is clear that claimant's supervisor was one Mr. Silas. The said Mr. Silas was not called to testify in this case, that he adequately trained claimant on the use of a corrosive substance, and that the claimant wears protective equipment, if at all same was provided. If at all, all this equipment was provided. Claimant, being the particular person affected, is a direct witness, and his testimony can only be validly dislodged by the said Mr. Silas, who, by the evidence of parties, was his direct boss and his supervisor. Is the only one who could validly dislodge the testimony of claimant as to him not being trained and giving protective equipment. The quality of claimant's evidence in this instance would be weightier than that of DW1, DW2, DW3, and DW4 put together, who are not claimant's direct boss, and one who would have a direct knowledge of the training of claimant and the fact that he was given personal protective equipment which he wears during his work routine. See the cases, the decision of this court in this case is Babatunde Ajala, Right Park Company Limited Supra, Dorothy Adaizi Awogu versus TFG Real Estate Limited on reported suit number NICN/LA/262/2013, judgment delivered on 4 June 2018. Mr. Charles Ugele and Access Bank PLC on reported suit number NICN/LA/287/2014, judgment delivered on 10 February 2017, and the case of Pastor Mrs. Abimbola Patricia Yakubu versus Financial Reporting Council of Nigeria and another on reported suit number NICN/LA/673/2013, judgment delivered on 24th November 2016. Again, the defendants who averred at paragraph 6 of the amended statement of defense that claimant was seen by other staff in playful mode while discharging his duties on the said date, which in turn caused him to lose concentration, failed to call the particular staff that saw claimant in the said playful mode. In fact, they did not even name the particular staff that saw claimant in the alleged playful mode. Besides, DW1, while under cross-examination, stated categorically and emphatically that claimant was appointed the head of the workers on the fateful day in the absence of his supervisor because he was diligent in his duty. The above testimony from a witness of a defendant attests to claimant's character while at work, that he takes his work seriously and diligent. Therefore, I do not believe the averment of the defendants, which is wholly unsupported by evidence that claimant on the said date was playful at work. At any rate, assuming the position of the defendants that claimant's injury was caused due to his playful mode is even true, same cannot stand in light of the decision in the case of Wilson and Clyde Coal Limited versus English, where the House of Lords in that case held that it is the duty of an employer to provide a safe system of work which is personal to the employer, and as such cannot delegate in such a way to absolve him from liability. Thus, even if the employer had delegated the duty to another person, he still remains accountable for workplace safety. In that case, the employee, while in the course of his employment, was crushed down by a haulage plant and died from injuries sustained, and his family brought an action against the defendant. The defendant, in his own defense, contended that the employee contributed to his own death because he should have told the person in charge of the machinery that he wanted to go the pit bottom, or he should have taken an alternative route. The House of Lords, in its unanimous decision, held that an employer's duty to provide a safe workplace and safe work system is non-delegable, and where such duty is delegated, same will not absolve an employer of liability. See also the English case of Smith and others, FC versus the Ministry of Defense. A defendant in this case, as seen above, made claimant work without supervision. Therefore, even if claimant was playful in the discharge of his duty, the defendants cannot absolve themselves of liability, having not shown that they made the work safe by providing claimant with the PPE, giving him strict instructions on how to use the said corrosive Magic 45, knowing fully well that the chemical is corrosive and dangerous to humans. Howsoever one views it, whether from the standpoint of failure to provide PPE and make sure claimant wears them, or from the standpoint of failure to train claimant and or failure to supervise claimant, I find that the defendants fatally breached their duty of care owed to claimants. I so hold. Let us consider the third element in the trilogy, which relates to resultant damage from the breach of the duty of care. Did the claimant suffer any injury or damage as a result of the breach of duty? In the present case, from the evidence before this court, claimant was injured in his eyes while at work on the 10th of May, 2019. DW1, while under cross-examination on 23rd of October 2023, admitted that the corrosive substance could splash on someone. Also, DW2, who said she was at work on the day of the incident, said that when she heard claimant's shout, she rushed to him and saw that the chemical had splashed on him. She even said that she and claimant were both rushed to a hospital because in her bid to help him, she also got burnt. Also in her testimony, claimant was in her word, quote, very, very injured, and unquote. Claimant, while under cross-examination by learned defense counsel, stated categorically that his left eye was affected and he cannot see with it. Undoubtedly, Exhibit M3 tendered by claimant and C1 tendered by the defendant itself. By the defendants, lend credence to the fact that claimant is visually impaired in his left eye owing to the chemical burn. In fact, there is no disputing that claimant, due to the injury sustained on the said date, is left with permanent disability on his left eye, as mere seeing him in court reveals this fact. In essence, the fact of the injury and the same occurred in the course of work is not in doubt. There is a saying that the light of the body is the eye. Thus, if one loses the eye, he has lost the light of his body. It is therefore clear that claimant has established that the defendants were so negligent in such a way that caused him injury or damage to his left eye. See the case of Mufutau and Adenini. It is in the light of all reasons above and earlier in this judgment that I find that release 1 and 2 succeed. In awarding damages for the tort of negligence, two main factors have to be taken into consideration in assessing damages in cases of liability. These are A, financial loss resulting from injury, and B, the personal injury involving not only pain and suffering, but also loss of the pleasure of life. See the cases of Ebe and Inamani, the case of Edi Monya and Dumes Nigeria Limited. The law is equally settled that a person injured by another wrong, as in this case, is entitled to general damages for non-pecuniary loss, such as pain and suffering, and loss of amenity and enjoyment of life. This may include a substantial sum for mental agony due to the fact that the quality of a person's life has been severely compromised. There is therefore no doubt that damages for personal injury can be awarded for permanent scarring or disfigurement, although there is no clear-cut principle for the quantum for the award of such damages. See Bello versus Dada and another, the case of Ingerio Novo and SCC Nigeria Limited. The court, in determining this, will most times consider the awards made by courts in similar cases in same jurisdiction or in other jurisdiction where similar socio-economic and industrial conditions exist. See the case of Kenneth, Ngosewe, and Delta Steel Company Limited. The courts have been enjoined to consider the biting effect of inflation and consistent depreciation of the value of the naira in awarding damages. See Ingere Rio Nyobo and SCC Nigeria Limited Subra, Ifeanyi Chukwu, Osondu Company Limited, and Ahibe. The defendant had contended that it paid all claimant's hospital bills after the incident, and that even after the incident, claimant's salary was still being paid, and he was not sacked by the defendant. They also contended that claimant even wrote letter of appreciation to the second defendant for paying his hospital bills, which claimant contended that he was forced to write as condition for continued payment of his salary. I must say that all these factors cannot operate to deny claimant damages for the permanent injury suffered in this case. At best, all those can be mitigating factors with regards to the quantum of damages to be awarded. We are in 2024, where the naira purchasing power has been greatly reduced. I have at the back of my mind that claimant's left eye is permanently disfigured and lost. That is, it is even obvious from his passport attached to his written statement on oath, as can be seen from the record of the court, and mere seeing claimant in the open court as I've stated supra. Claimant, no doubt, has to live with his permanent disability for life, which undoubtedly will affect the quality of his life, his productivity, his self-image, and self-worth. Basically, no amount of money can assuage or compensate for the permanent disability suffered by the claimant, who was described as a very hard-working and diligent in his work at the defendants. This court is empowered by Section 19D of the National Industrial Court Act to award compensatory damages in deserving cases. In view of the resultant damage to claimant's left eye by the defendant's negligence and the permanent incapacity suffered by claimant as a result, and in the exercise of my powers under Section 19D of the National Industrial Court Act, I hold that claimant is entitled to damages having considered the permanent disability to his left eye and the current inflation rate in the country as at March 2024, assessed from the Bureau of Statistics, MBS, is 33.2%, which is on the very high side, as opposed to the inflation rate in 2019, when he sustained injury, which was at 11.40%. Needless to also say here that no amount of money can adequately compensate for the permanent loss of claimant's left eye. I therefore, considering all stated herein before, award the sum of 25 million naira as general damages or compensation for the permanent loss of claimant's left eye. I so award. Claimant by Relief 3 is saying that failure of the defendant to provide the initial cash deposit for his treatment, that delayed payment amounts to an unfair labor practice. He averred via paragraph 17 and 19 of his statement of fact that the defendant failed to give the doctors the details of corrosive substance in order to determine the line of medication, and also failed to pay the hospital the sum owed. In fact, he averred in paragraph 20 that the human resource manager, one Patricia Chukwu, told him that the defendant does not have money for his treatment. The defendant asserted the opposite, that he provided the details of the corrosive substance and paid for claimant's medical bills, and even have retainership with the hospital and even tendered SBC in support. They also said that claimant had no time complained of non-treatment. Rather, claimant came to request for money to buy eye drops. The concept of unfair labor practice became constitutionally recognized by Section 254C1F of the 1999 Constitution as amended, and which power to strike down such practice is given to this court by that provision. However, it must be noted that the question of unfair labor practice is a question of fact that must be shown and proved on record. See the case of Oak Pension and Olayinka, citation provided. The right of an employee to protection against workplace injury is enshrined in the Universal Declaration of Human Rights, 1948, and the International Convention on Economic, Social, and Cultural Rights, which is also known as ECOSOC rights. Also, the International Labour Organization reads its Employment Injury Benefits Convention number 121 of 1964, and its accompanying recommendation also underscores the right of employee in case of employment injury. Articles 9, 10, 11, and 12 of the convention are very instructive as to access to medical care for workplace injury. Although Nigeria has not ratified the convention, this court in its power to apply international best practice, but then the facts of each case has to be considered. The position of the law is settled that the scale of evidence oscillates as the scale of evidence preponderates. See the cases of APM versus INEC, Equazor, and registered trustee of SACN. See also Section 132 of the Evidence Act. The defendant having tendered Exhibit C, the evidential burden in this case moved from the defendant to the claimant to lead an evidence in rebuttal. Claimant who want the court to believe that the defendant failed to pay for his medical care at Maitama Hospital, which led him being denied access to medical care, failed to lead any credible evidence in support of same in the light of SBC, which show that defendants at different times paid for claimant's medical bill. In fact, claimant's counsel failed to cross-examine DW1 on her testimony in paragraph 4 that she never told claimant that the defendant did not have money to pay his hospital bills when he was cross-examining her on the 23rd of October 2023, which is a tacit acceptance of her testimony. See Gambo and Isan and other Supra, Zenith Bank, and Akwa International Limited Supra. The claimant, in my view, has failed to show that the defendant failed to pay for his medical treatment, and which failure is an unfair labor practice. Claimant has equally failed to prove his assertions, and I find no reason why this court should grant relief 3. Relief 3 is thus dismissed. Claimant viewed relief 5 claims for general damages in the sum of 50 million naira for failure of the defendant to train claimant in the use of corrosive substance. When a party has suffered wrong as a result of another's action, what the law seeks to do is ensure the victim is adequately compensated. Thus, where a party has been fully compensated under one head, the law frowns at awarding such party another compensation for the same act under another head. See the case of Nyako and UBA PLC, Agua and General Oil Limited, British Airways and Atoyebi, Sokwa Motors Nigeria Limited and UBA. Having granted the claimant compensation for the loss of his eyes, which is occasioned by the breach of duty of care owed to him, it would amount to double compensation to award claimant damages for failure of the defendant to train him on how to use corrosive substance, which is part of a duty of care owed him, and which failure he has been adequately compensated in the preceding relief 4. Thus, relief 5 fails. I'll take relief 6 and 7 together. Claimant by relief 6 is asking the court to order payment of his salary in the sum of 150,000 naira from the months of April, May, and June 2020. By his relief 7, he's asking the court for an order that the defendant pays him 30,000 naira as arrears of monthly salary payable from month of February 2021 until judgment is delivered. Claimant by relief 25, by paragraph 25 averred that the defendant failed to pay his monthly salary for the months of April, May, and June 2020. He also stated that by paragraph 20 of his statement of facts that he was still in the employment of a defendant till February 2020 when he stopped paying his salary. He stated again in paragraph 26 that upon writing a letter of appreciation, the defendants began to pay his salary again from August 2020 until he stopped in February 2021. The defendants bid their amended statement of fact averred that claimant was paid March 2020 salary, along with others before the COVID-19 lockdown, which commenced on 25th of March 2020, and that the defendants only resumed paying his salary after partial reopening of the defendants post-COVID until he opted to resign. There's no doubt that salary is payment for work done, and an employee cannot claim for salaries for work not done. See Skybank PLC versus Mr. Adedoku Olusegun Adegun, unreported appeal number SC/406/2018, which judgment was delivered by the Apex Court on the 27th of February 2024. The case of Balogun and Union Bank, citation captured, CCB Nigeria Limited and Inwako, citation provided, Olatuboso and Naisa. This court is empowered to take judicial notice of notorious facts, and in respect of which proof is no longer necessary. See Adeleke and Oyetola. The case of Umaru and FRN. This court takes judicial notice of the notorious fact that the COVID-19 lockdown commenced on 30th of March 2020 in Nigeria till 15th May 2020, during which all businesses were shut down. CW in this case is claimant's biological brother by his oral evidence as contained at pages 335 to 341 of the record. CW1, when asked under cross-examination on 1st February 2023 by Learned Defense Counsel whether claimant worked for the defendant for the months of March, April, May, and June 2020, he answered that before the accident, claimant was not paid during COVID-19 lockdown as claimant was relying on him. By the fact of this case and the uncontroverted evidence, the incident happened on the 10th of May 2019, and CW1 would want the court to believe that claimant was not paid before the accident during COVID-19. It means that it's saying that claimant was being owed before May 2019 when the incident happened. Claimant in this case is claiming for salaries for April, May, and June 2020 after the incident and not before, contrary to the evidence of CW1. Claimant who would want the court to believe that is entitled to be paid for the said period has the burden to show that he worked during those periods. He, in this case, failed to substantiate his claim that he worked for the defendant during the period of April, May, and June 2020. And so I refuse this claim. At any rate, the claimant has not worked for the defendant since February 2021. As a matter of fact, by paragraph 1 of his statement of fact, he averred that he was an employee of the defendant. He did not say that he's still in the employment of the defendant till this present. In fact, besides, it is clear from the facts of this case that claimant is no longer in the employment of the defendant. Claimant cannot thus choose to treat his employment as still subsisting by claiming for salaries from February 2021 till today being the judgment day. The employment relationship has been severed as shown by the uncontroverted evidence of the defendants that claimant resigned since February 2021. Thus, claimant having not worked for the defendant since February 2021 cannot be claiming salaries from the said period. Besides, the law is settled that the court cannot force an employee on an unwilling employer. CMOE and FAAN, ABBA and Benue Cement Company PLC and another. Ordering that claimant should be paid for the said periods till now is tantamount to foisting a willing employee on an unwilling employer, which is outside the power of this court to do. The law equally frowns at payment of salary without work. In view of all reason above, relief 6 and 7 fail in their entirety. Claimant in this case pleaded alternative facts in line with the alternative relief sought under the Employees' Compensation Act. It is the law that a party who claims a relief in the alternative is allowed to plead conflicting facts in line with the alternative relief sought. See unreported petition number CAPEPC/03/2023, CAPEPC/04/2023, CAPEPC/05/2023, Mr. Peter Gabriel B. and another versus INEC and others, APM versus INEC and others, Abubakar Atiku and another versus INEC and others, delivered on Wednesday, 6 September 2023, Adige G. and Wagu and others, the case of Metal Construction WA Limited and Aboderi. However, it is important to note that an employee cannot claim both under the statute, that is the Employee Compensation Act, and under common law. Once an employee pursues, as done in this case under the common law, he cannot toll the part of the Employees' Compensation Act. See the decision of this court in the case of Batudia Ajala and Wright Park Company Limited Supra, where this court held that the employee who has claimed under common law cannot claim again under Workmen's Compensation Act, which was repealed by the Employees' Compensation Act. The court emphatically at paragraph 51 of its judgment held thus, I quote, "As a last point, I must state that in seeing as he did, the claimant chose the path of common law liability and negligence, not the path of the Workmen's Compensation Act. The act that will have applied had the claimant sued under statute law. This is a choice claimant had, and he is entitled to choose any of the two forms of liability, that is, liability under common law or statute. He chose the former," unquote. The above fact is also underscored by section 12(1) and 2 of the ECA, that is Employees' Compensation Act, which goes further that the benefits under the ECA are in lieu of any right of action, statutory or otherwise founded on the breach of duty of care or any other cause of action, whether the duty is express or implied, to which an employee or his dependent may be entitled to against the employer whose conduct caused the breach, and the injury must have arisen in the course of employment. In the case of Udemba and Mwabwezi, the court held that as regards the meaning of the phrase, quote and unquote, in lieu, according to the learned counsel for the appellant and in line with the definition of a term in lieu by Black's Law Dictionary 9th edition at page 558, see also page 791 of the 7th edition, has rightly submitted that it means, quote, instead of or in place of, in exchange or return for, unquote. Thus, applying the definition to section 12 of the ECA above, it means the benefit under the ECA, including that of compensation for an injured employee is in place of the right of action founded on breach of duty of care, whether expressly or implied by the employee or his dependents against an employer for the breach that occurred in the course of employment. Thus, pursuing an action at common law and under ECA are mutually exclusive. Going for one automatically extinguishes the other. It is in view of the above that this court does not consider all the facts of this case dealing with the contribution under the ECA and all the resultant effect. In addition, it is the law concerning alternative reliefs that alternative reliefs will only be considered where the main claim cannot be granted or fails. On this, see the cases of Usuji and Ekocha, Caroline Maersk, sister vessel to MV Christian Maersk versus Nokoi Investment Limited, Agidigbi and Agidigbi, Yesufu and Kupo International NV. Claimant's main relief under the tort of negligence has succeeded. There will be no need to consider his alternative reliefs. It is in view of the above that this court discountenances the alternative reliefs. The position of the law is clear as regards the award of post-judgment interest. It is true that post-judgment interest, which is an interest on judgment debt, is statutory and may be awarded even where it was not pleaded, as it is at the discretion of the court. See Schemate Motors Limited and UBA PLC, Amber Resources Nigeria Limited and Century Energy Services Limited. It is usually granted where a claimant has sought monetary claims which have succeeded. However, the rules of court regulates the discretion of the court by setting the rate or percentage at which such post-judgment interest may be awarded. See the case of Bolanley and Access Bank. This court is empowered by the provisions of Order 45, Rule 7 of the rules of this court, as captured in Bolanley's case supra, to grant post-judgment interest at a rate not less than 10% per annum. Claimant has sought monetary claims which have succeeded and sought post-judgment interest of 10%, which is within the bracket allowed by the rules of this court. Thus, in my view, claimant is entitled to post-judgment interest. I therefore exercise my discretion in favor of the claimant by awarding 10% post-judgment interest on the judgment sum. Relief 8 does succeed. The law is settled that costs, including with regards to the cost of action, costs, including cost of action, is granted to a successful party and should not be denied except for good reason. So the case of Kappa and Alberto PLC versus NDIC, Yakubu and Minister Housing and Environment, Yakubu and Ministry, Housing and Environment, Bauchi State citation captured. The award, of course, is at the discretion of the court, which discretion is to be exercised judicially and judiciously, most especially where empowered by its rules. Claimant in this case has succeeded in the most part of his claims against the defendants. Order 55 of the rules of this court, 2017, empowers this court to grant cause of action at its own discretion. In the exercise of my discretion, considering the number of processes filed and appearances had in this case, I award a cost of 500,000 naira in favor of the claimant. I so award. For the avoidance of doubt and reasons earlier given, I declare an order as follows. 1, the defendants breached the duty of care owed to claimant, which resulted in the permanent loss of his left eye. 2, claimant is entitled to the sum of 25 million naira as compensation or damages for loss of his left eye owing to the negligence of the defendant. 3, claimant is awarded the sum of 500,000 as cause of action. And 4, this judgment is to be complied with within 30 days of delivery of same, that is within 30 days from today, failing which it shall attract 10% post-judgment interest, simple interest per annum. Judgment is accordingly entered.
As the court pleases.
As the court
Lord,
pleases.
we are most grateful for your well-considered judgment. May my Lord be pleased.
So you're entitled to a copy, which you may send for it by tomorrow. I only observe some little typos, which will be corrected.
As the court pleases.
Very well. So I'll rise.